Washington came to a complete standstill. The single decision that political insiders have been speculating about for weeks was finally confirmed, and the shockwaves are reverberating through every corner of the Capitol. We're not talking about a policy announcement or a routine appointment that gets debated and forgotten. This is a decision that fundamentally reshapes the balance of power in Washington, triggers immediate legal and political consequences that cannot be reversed, and forces every major political player to recalculate their entire strategy going forward. When the Supreme Court announces it will hear a case that could permanently disqualify Trump from holding federal office, when that announcement comes with an expedited hearing schedule that bypasses all normal procedures, and when the court's order specifically requests briefing on whether the 14th Amendment's insurrection clause is self-executing, constitutional history is being written in real time. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what is this earth-shattering decision? On February 27th, the Supreme Court issued a one-page order announcing it will hear arguments on whether Trump is constitutionally disqualified from holding office under Section 3 of the 14th Amendment, which bars anyone who engaged in insurrection from holding federal office. The decision to take the case isn't surprising, but three specific elements caused Washington to freeze. First, the court scheduled oral arguments for March 15th, giving the case priority over everything else on the docket. Second, the order specifically asks both parties to address whether Section 3 is self-executing or requires congressional action to enforce. Third, and most critically, the court stated it will issue its ruling by April 1st, ensuring a decision comes down months before any presidential campaign intensifies. This isn't the court dabbling in politics. This is the court moving with unprecedented speed to answer the most consequential constitutional question since Bush versus Gore. Here's what's been building to this moment. Multiple state courts and secretaries of state have grappled with whether Trump's actions on and around January 6th constitute engagement in insurrection that triggers the 14th Amendment disqualification. Colorado's Supreme Court ruled that Trump is disqualified and ordered him removed from the ballot. Maine's Secretary of State reached the same conclusion. Other states dismissed challenges on procedural grounds without reaching the constitutional merits. The patchwork of conflicting decisions created an untenable situation where Trump might appear on ballots in some states but not others, raising fundamental questions about whether we'd have a functioning presidential election. The Supreme Court had to intervene to create national clarity, but the specific questions posed in the February 27th order reveal that the court is taking the constitutional issue deadly seriously. The order asks parties to address whether Section 3 is self-executing, meaning it operates automatically when someone engages in insurrection, or whether Congress must pass legislation to enforce it. This question is critical because if Section 3 is self-executing, then Trump is already disqualified, and states can remove him from ballots without any congressional action. Conversely, if congressional action is required and Congress hasn't acted, Trump remains eligible regardless of whether he engaged in insurrection. Legal scholars have debated this question for months, with compelling arguments on both sides, but the Supreme Court will now definitively resolve it. Smash that like button if this is making sense so far. Here's where the implications become staggering. The court also asked parties to address the factual question of whether Trump engaged in insurrection within the meaning of Section 3. This is extraordinary because the Supreme Court typically avoids factual determinations, preferring to resolve pure questions of law and leave fact-finding to lower courts. By specifically requesting briefing on whether Trump's conduct constitutes insurrection, the court is signaling it may resolve that factual question itself rather than remanding to lower courts. If the Supreme Court concludes that Trump engaged in insurrection, that finding would have immediate and permanent consequences across every aspect of American political and legal life. What happened next on February 28th revealed just how seriously Washington is taking this decision. Both major political parties immediately convened emergency strategy sessions. Republicans are facing the nightmare scenario where the Supreme Court, including 3 justices Trump himself appointed, could disqualify their likely presidential nominee. Democrats are grappling with the possibility that Trump could be removed from ballots not through electoral defeat, but through constitutional disqualification, which would fundamentally alter the 2024 election landscape. Trump's legal team filed a motion requesting 60 days to prepare their brief, which the court denied within 4 hours, ordering briefs submitted by March 8th. That denial signals the court's determination to resolve this question quickly. Drop a comment right now if you saw this coming. I read every single one. The most telling reaction came from Senate Republicans who've defended Trump through 2 impeachments and countless scandals. Multiple Republican senators told reporters on February 28th that they were deeply concerned about the Supreme Court's order and that the party needed to prepare for the possibility that Trump might not be the nominee. Senator John Cornyn stated that while he believed the disqualification efforts were politically motivated, the Supreme Court's decision to hear the case and specifically address whether Trump engaged in insurrection suggested the court viewed the constitutional question as serious and substantial. Senator Mitt Romney went further, saying the court's expedited schedule and specific questions indicated that at least some justices believe Section 3 may apply to Trump's conduct. When Senate Republicans start publicly hedging on Trump's eligibility, when they're openly discussing contingency plans for a nominee who might be constitutionally disqualified, the political ground has shifted beneath everyone's feet. This isn't the first time the Supreme Court has been asked to resolve an election-related constitutional crisis. Bush v. Gore in 2000 saw the court intervene to stop Florida's recount, effectively deciding the presidential election. The decision was controversial and remains disputed, but the court acted with similar speed, hearing arguments and issuing a decision within days. The Trump eligibility case has elements that make it even more consequential. Bush v. Gore resolved a dispute about vote counting in a single state. This case could determine whether a candidate can appear on ballots nationwide. In United States v. Nixon, the Supreme Court ruled that President Nixon had to comply with a subpoena for White House tapes. That decision led directly to Nixon's resignation within weeks. The court's willingness to rule against a sitting president established that no one is above the law, but it didn't remove Nixon from office directly. The 14th Amendment case could result in the court directly disqualifying Trump from holding office, an action with no precedent in American history. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The pattern from these precedents is clear. When the Supreme Court intervenes in politically charged cases with expedited procedures and specific pointed questions, the court is preparing to issue a consequential ruling that will reshape American politics. The speed of the current proceedings, the specificity of the questions posed, and the court's insistence on an April 1st deadline all suggest the justices recognize the magnitude of what they're deciding. So what specific legal arguments will determine the outcome? Trump's legal team will argue that Section 3 requires congressional implementing legislation before it can be enforced, that the events of January 6th don't constitute insurrection as that term is used in the Constitution, and that as President Trump was not an officer of the United States within the meaning of Section 3. Each argument faces significant legal obstacles. The self-execution question turns on constitutional text and historical evidence from the Reconstruction era when Section 3 was adopted. Multiple legal scholars, including prominent conservative originalists, have concluded that Section 3 was designed to operate automatically without requiring congressional action. The text says that anyone who engaged in insurrection shall not hold office, using mandatory language that suggests immediate effect rather than conditional enforcement. Don't go anywhere. The most explosive part is coming next. Historical evidence shows that Section 3 was enforced against Confederate officials immediately after the Civil War without any implementing legislation. If the Supreme Court follows originalist interpretation, which several conservative justices claim to favor, the historical evidence strongly supports self-execution. The insurrection question is even more damaging for Trump. Insurrection is defined as organized resistance to government authority through force or violence. Trump's conduct on January 6th, rallying supporters with false claims of election fraud, directing them to march to the Capitol, and then failing to stop the violence for hours while it unfolded, creates a compelling factual basis for concluding he engaged in or supported insurrection. This puts the Supreme Court in an extraordinarily difficult position. On one side, ruling that Trump is disqualified would trigger massive political backlash from Trump's supporters and accusations that the court is interfering in democracy by removing a candidate from the ballot. The political consequences would be severe, and the court's institutional legitimacy could suffer. But on the other side, ruling that Trump remains eligible despite evidence that he engaged in insurrection would effectively nullify a constitutional provision specifically designed to prevent insurrectionists from holding office. If the 14th Amendment's insurrection clause doesn't apply to someone who rallied supporters to prevent the peaceful transfer of power, then it applies to no one and becomes meaningless. And here's the constitutional calculation that makes this case different from typical political questions. The court isn't being asked to choose between candidates or decide a policy dispute. The court is being asked to interpret constitutional text and apply it to specific facts. This is exactly what courts are designed to do. Avoiding the question because it's politically sensitive would be an abdication of judicial responsibility. Legal and constitutional scholars across the political spectrum are calling this the most important Supreme Court case since Brown versus Board of Education. Lawrence Tribe, Harvard law professor, told CNN that the court's decision will either reaffirm that constitutional provisions have meaning and must be enforced, or it will establish that politically powerful figures can violate the Constitution with impunity. The 14th Amendment was adopted specifically to prevent insurrectionists from holding power, Tribe explained. If it doesn't apply to January 6th, when a president tried to prevent the peaceful transfer of power through force, then the amendment is a dead letter. Michael McConnell, former federal judge and Stanford law professor who is generally conservative, wrote that the textual and historical evidence supports self-execution of Section 3 and that Trump's conduct on January 6th appears to meet the constitutional definition of engaging in insurrection. While acknowledging the political sensitivity, McConnell argued that courts must apply the Constitution as written regardless of political consequences. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even some conservative legal scholars who've defended Trump in other contexts have acknowledged the strength of the disqualification arguments. J. Michael Luttig, former federal appellate judge appointed by George H.W. Bush, filed an amicus brief arguing that Section 3 is self-executing and applies to Trump's conduct. The Constitution means what it says, Luttig wrote, and the court cannot ignore constitutional text because enforcing it would be politically inconvenient. The immediate impact of the Supreme Court's decision to hear the case is already reshaping the political landscape. Republican donors are reportedly hedging their bets, with some major contributors quietly reaching out to potential alternative candidates in case Trump is disqualified. The Republican National Committee has begun preliminary discussions about what would happen to Trump's delegates if he's removed from ballots after winning primaries. Trump's campaign has seen a decline in fundraising as uncertainty about his eligibility creates donor hesitation. Second, state election officials are in limbo. Some states have primary elections scheduled before the Supreme Court's April 1st deadline, creating the possibility that Trump could win primaries but then be disqualified before the general election. Election administrators are quietly preparing contingency plans for scenarios no one has faced before. Finally, this creates massive pressure on the Supreme Court itself. The justices know their decision will be scrutinized more intensely than perhaps any ruling in modern history. They know that millions of Americans will view any decision against Trump as partisan judicial activism, regardless of the legal reasoning. But they also know that failing to enforce a clear constitutional provision would undermine the court's core function. Drop a comment below with your thoughts. But beyond the political chaos, this is about whether constitutional provisions matter when enforcing them is politically difficult. The 14th Amendment exists for this situation. If the provision cannot be enforced when needed most, constitutional text becomes suggestion rather than law. Republicans are in turmoil. Leadership must prepare for their leading candidate being potentially disqualified. They must manage Trump's reaction and consider whether to rally behind him or prepare alternatives. Trump's response has been incendiary, attacking the court and claiming witch hunts, but his legal team's briefs are more measured, recognizing inflammatory rhetoric won't help. The disconnect shows his impossible position. Stay with me because what comes next will completely change how you see this. Here's what makes the Supreme Court's decision so consequential. The court isn't just deciding whether Trump can be on ballots in 2024. The court is defining whether the 14th Amendment's insurrection clause has any force. whether constitutional provisions designed to protect democracy can be enforced against popular political figures, and whether the rule of law applies when politically inconvenient. The precedent set will govern American constitutional law for generations. This goes far beyond Trump or any single election. It's about whether constitutional provisions protecting democratic governance can be enforced or whether they become dead letters when enforcement requires political courage. If someone can lead an insurrection, prevent the peaceful transfer of power, and then run for office again because disqualifying them would be politically divisive, then constitutional protections of democracy have failed. The stakes are existential. If this blows your mind, hit that like button right now. Here's the situation. The Supreme Court will hear arguments on March 15th and issue a decision by April 1st on whether Trump is constitutionally disqualified from office under the 14th Amendment. The court has asked whether Section 3 is self-executing and whether Trump engaged in insurrection. Legal scholars across the spectrum acknowledge the constitutional arguments for disqualification are strong. Republican leadership is preparing contingency plans. State election officials are in limbo. The entire political establishment is holding its breath, waiting for 9 justices to decide whether constitutional text means what it says. Keep watching because this is developing daily. The briefs will be filed by March 8th. Oral arguments happen March 15th. The decision comes April 1st. Between now and then, every word from the justices, every legal filing, every political development will be analyzed for clues about how the court will rule. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. The Supreme Court has taken the most consequential constitutional case in modern history. The court will decide whether Trump engaged in insurrection and is therefore disqualified from holding office. The decision comes with unprecedented speed on an expedited schedule. Legal scholars say the constitutional arguments for disqualification are powerful. Political Washington is frozen, waiting for the ruling that will reshape American democracy. This isn't a case that will be decided and forgotten. This is the Supreme Court determining whether constitutional protections of democratic governance can be enforced against the most politically divisive figure in modern American history. Either the court applies the Constitution as written and disqualifies Trump, establishing that constitutional provisions protecting democracy must be enforced regardless of political cost, or the court finds reasons to avoid disqualification, establishing that sufficiently popular political figures can violate constitutional prohibitions with impunity. What happens when the court rules will define American constitutional democracy for generations. The arguments are scheduled. The deadline is set. The constitutional question is posed. Now we wait to see whether the Supreme Court has the institutional courage to enforce the Constitution when it matters most. The stakes for American democracy have never been higher. The constitutional question has never been more clearly presented, and Washington has never been more frozen, waiting for a single decision. Pause for a second and hit that like button if you're finding value in this coverage of the most important Supreme Court case of our lifetimes.